And I put it in the chat, but I just want to give a reminder that we do record these, so recording just started.
And if everybody could put in the chat your name and where you're from, that would be great too. Okay, Mandy.
Hello, everyone. So super excited. We have a very packed agenda today. So I'm going to quickly move us into our first presentation. So our first presentation of the day is with Mary Lennon Vasquez from Social Security Administration. I think you should be able to share your screen, Mary Lennon. Let me know if you can't. Hoping I did this right.
Let me see. Yeah, no, that's why I did send my PowerPoint in advance.
Okay.
You should have it.
Let me pull it up. Oh, I have it somewhere. And in the meantime, can you just introduce yourself to the group while I get this open?
There's no sanity, but there are meals. You know, you can have one meal or 2 drinks, and 2 drinks.
See that?
Yeah, there you go.
All right, I'm gonna kick it off over to you then for introduction.
Yes, good morning. Can everybody hear me?
Yes.
Yeah, okay. So my name is Mary Lennon Vasquez. I am the Public Affairs Specialist for the Social Security Administration. And I am out of Lawrence, Massachusetts, but I've worked many years in the Manchester field office. So I'm very familiar with New Hampshire. I also worked in the Concord field office administering the Social Security program, Social Security disability, supplemental security income, Medicare, and stage renal disease, you name it. So while I am an expert in the subject, I don't know everything. So what I tell people is that whether you're referring someone to Social Security to apply for benefits, whether you're helping someone apply for those benefits, always first visit our website, socialsecurity.gov, also in Spanish and other languages. So we want people to know that, yes, we're open. We are, every office is open Monday through Fridays, 9 to 4. But as an option for the many that need to apply and submit an application, we have our website, which they can easily go ahead and set up an application and also submit one. So today I'm going to go through the SSDI, Social Security Disability Program, and SSI, Supplemental Security Income Program. And just, my goal is for today for you guys to have a better understanding about the Social Security programs. One thing that I want to mention is that anyone who is age 18, who has an email address and also a US address, can go online at ssa.gov and create a My Social Security account, including yourselves. So the majority of us paid into the system. So if you're not 6 years old, you should go online and create the My Social Security account, which is your own personal account with the agency, so that you can see how much you've paid into the system, how much would you be eligible if you were to apply for disability or supplemental security income. So it's just a lot of information that is available to you guys and to the public that you serve at ssa.gov. So I do encourage everyone to go online and create a My Social Security account so that you can see what it looks like. In that in the event you're helping someone apply, you will be able to help that person create an account. So we're going to go to our first slide. Next. All right, so we're gonna take it by program. So we're gonna start with the Social Security disability. And you must know that in order to qualify for Social Security, whether it is disability or supplemental security income, Social Security has to make a decision that says that you are disabled. So SSA defines disability as a person who is not able to work due to a severe medical condition that has lasted or is expected to last at least 12 months or result in death. So when we say a severe medical condition, that means that that condition prevents you from lifting, sitting, just doing the basic things that your job require you. Now, if the person is working and they're applying for the first time for Social Security disability, they can do that. So we can find that a person has a condition that it's so severe yet is working, and we say the person's medical condition must prevent him or her from doing substantial gainful employment. So you might be able, someone who wants to apply for Social Security but is working, we can say that we can take the application as long as that person is not earning more than 1,460. If the individual has a disability but is not earning more than 1,460, Social Security will take the application and make a disability determination. At the field office level, we take the application, that is the non-disability application, we take all the medical information, and then that gets forward to the disability determination services. Usually in New Hampshire, it's Concord, New Hampshire, where a group of doctors are the ones making the medical decision.
Okay.
Next. Okay, so when it comes to Social Security disabilities, we say that in order to be eligible, not only you have to be disabled, again, by the Social Security guidelines, but you also must have paid into the system, depending on your age. So the younger you are, the less work that you have to have. And just to give you an idea, if we go to the next slide, if you develop a disability and you become disabled in or before the quarter you turn age 24, we say that that person only needs 1.5 years of work during the 3-year period ending with the quarter that they developed the disability. If they became disabled after age 24, but before the quarter they turned 31, they only need to have worked half of the time, beginning from the period that their disability began after they turn 21. So this is very technical. So the easiest way an individual can really know if they're eligible for disability, it's to go online at ssa.gov, create that My Social Security account, and see if they're eligible for benefits based on their earnings. Another way is to contact the field office and set up an appointment. We don't want people to be discouraged by saying, I think there's a misconception out there that you always get denied the first time. That is not necessarily true, but the person must have to have paid into the system. Then again, we don't want people to make that decision. Let Social Security make that decision. The most common one that we see someone being disabled or having a disability after age 31, and we say that in that instance, they must have worked during the 5 years out of the last 10. If they haven't been able to pay into the system and worked in 5 years out of the last 10, then regardless of whether or not they have a disability, they will not be eligible for Social Security disability. Nonetheless, we also have another program that I'll talk about. And if they're eligible based on income and resources, then we might look into the SSI program. So when we talk to someone, we're always finding, asking the right questions to see if they might be eligible for other programs if they don't have enough work under the Social Security Disability Program. Next. This just tells you it's an idea just to get, how much work someone needs when they become disabled. And before age 28, they only need 1.5 years of work. Age 30, 32 years, age 34, 3 years, and so on. And then again, this is very technical. We don't expect people to know this, but the easiest way to get to know if you are eligible, potentially eligible for Social Security disability based on earnings, and that's the first thing that we look at, is to first create that My Social Security account, which I, before this presentation, I provided a number of links that will get you directly to the types of programs and how to apply it and how to create an account. So I'm pretty sure Amanda did share that with you guys. The next screen. All right, so when should someone apply for disability benefits? We said apply as soon as you know you're not either able to work because of your condition, or you're working but you're not earning more than $1,460 per month. When you applied, which you can either again do it online at ssa.gov by creating a My Social Security account, we at the field office level, we take the application and we forward that to the disability determination services. So that initial claim, right, when someone first applies, can take anywhere between 3 to 5 months. Right now, even longer, about 7 to 8 months, okay? So what we want people to know, that if you apply for Social Security disability, is that any changes, you update the agency with any changes, because if we're looking to speak to someone, we can find that we can deny the application just based on that. So sometimes Social Security has what we call compassionate allowances. In those instances, if the person has a terminal illness, we can make a decision within a week. Now, when you first apply for Social Security, there is a 5-month waiting period from the day that you apply, from the day that you became disabled. So let's say that if I became disabled today, which is May 9th, I have to serve a 5-month waiting period in full 5 calendar months. So if I became disabled to date, I came into an office, I submitted my application, even though it might take 3 to 5 months, first month that I can be eligible is after I serve my 5 full calendar months. If I became disabled today, 5 full calendar months waiting period, there's no payments. It would be June, July, August, September, October. The first month that I can start getting Social Security disability benefits would be June, July, August, September, October, November of 2023. Social Security pays a month behind, so the November check will be paid in December. Next slide. Okay. So there's a few ways to apply for Social Security disability. Again, you can set up an appointment with your local Social Security field office. You can call a 1-800 number 772-1213 and set up an appointment between the 8 a.m. and 7 p.m. But the easiest way and to know what you're going to need, it's to go online at ssa.gov/disability. So online, we give you a synopsis as to what the program entails, what to expect once you applied. We even have a starter kit that tells you what are we going to need for your Social Security disability, so the application, so that you can get prepared. And I'm going to go into that. So you guys have options. If you're referring someone, helping someone, I would say the first stop would be to go online to ssa.gov/disability, or simply ssa.gov, and either create the account. So if the individual is applying for him or herself, they must create a My Social Security account first. But if you are an organization that you're helping someone apply for benefits, if you have the person with you, or if you've set up an appointment with that person, you wouldn't have to create an account for that person. You can go ahead and file them on behalf of that person, that disabled individual, that applicant, and you can go ahead and do all the application for to completion. Next slide. Okay. So what happens next? I think I talked a little about this. So at the field office level, we first make sure that based on your age and based on the age that you became disabled, you have enough work to be eligible for Social Security disability benefits. If you meet the work requirements, then we'll forward the application to the Disability Determination Services. For New Hampshire, DDS is located in Concord, New Hampshire. Next. Okay, so DDS is responsible to make that disability decision at the state level for Social Security. So what I tell individuals, then again, once you set up an appointment with the field office, we'll send you a starter kit. Again, you can find this online at ssa.gov. So it is very important that the person is as detailed as possible, because when so there's two components to the application. There's the non-disability application, in which we ask you, first we look at work, whether or not you have enough work to be eligible. And then we look about the names of any children under the age of 18 or disabled prior to age 22. We ask for any marriages that have lasted at least 10 years. So that's we ask you about the work that you've done in the last 15 years prior to the day that the person became disabled. So that's the non-disability. Then we go into a disability report that is very extensive, and we ask you to provide names of doctors, the dates of the first visit, and the date of the last visit, the next visit. We ask you to provide the names of hospitals, clinics, any emergency visits, the dates of those emergency visits, the date of outpatient, inpatient hospitalizations. We ask you the highest grade completed in school. So what I tell people is, you can call us, set up an appointment, but before your appointment date, either go online at ssa.gov/disability, get that starter kit and start writing all your medical information, because we do ask that you complete a disability report and also provide SSA with that authorization to disclose information from your medical provider, so that we can make a decision. But the more in detail the person is, and even provide us with that medical records, will make the disability decision a little bit faster. Next. Okay. So Social Security uses a 5-step sequential system to determine if the person is disabled under the Social Security guidelines. So the first step asks whether a person is working. So if the person is not working, we go to step 2. is the medical condition so severe that the person cannot do any type of work in the general economy, or cannot do basic work activities such as lifting, standing, walking, sitting, or remembering for at least 12 months. So I told you that if the person is working, they cannot be engaging in substantial work, and we give that a dollar amount. In 2023, a person who is disabled might submit an application for Social Security and still work. And as long as that person is not engaging in substantial work, earning more than $1,460, we will continue with the disability decision. Now, the second step is to see if the person's condition is so severe that prevents them from doing basic work activities. If it's severe enough, then that person is determined to be disabled. If we find that it's not, that the person's condition is not so severe, then we go to step 3. Does the person's impairment meet or it's equal to SSA's medically listings? So we have a number of listings on our website that if they meet one of those listings, such, cancer at stage 4, if they meet those medical listings, then we say that person is disabled. If they don't meet that, then we look to see whether or not that person can go back to the type of work that they did before they became disabled. If they're not able to go back to the same work that they did before they became disabled, then they're determined to be disabled. Now, if they can go back, then we look at step 5. Can they do any type of work in the general economy? And if they do, then they will be determined not to be disabled. If they can't do any type of job in the general economy, then they will be found to be disabled. This is something that we don't expect organizations to know, but just to be aware how the sequential system that SSA uses to determine whether a person is disabled or not. We don't want people to be discouraged to say, my condition is not severe enough, or maybe I can go back to work. Let the agency make that decision. Next. Okay. So once we make that initial determination, which again, right now can take up to 8 months. And by the way, if the individual creates that My Social Security account, one of the benefits of creating such account, either at the initial claim or after the person files, is that at every step of the process, whether it is at the field office, whether the claim is pending at the disability determination services, and any other component of the agency, if the individual creates that My Social Security account, they'll be able to see the status of the account of the claim. So if it's pending at the disability determination services, it lets them know that it's being reviewed for a decision. Once the disability determination services, it lets them know whether it was approved or denied, and it's pending at the field office. So my advice is that if you're helping someone, referring someone to apply for disability, encourage them to create that My Social Security account, because whether it is at the initial claim or if they get approved, they'll be able to manage their benefits online through the My Social Security account. Now, if DDS approves the claim, we'll send a letter by mail letting them know when benefits start and what are the reporting responsibilities. And I can tell you that once a person is approved for a Social Security disability, we need to know whether they have gone back to work, they have stopped working, whether they have any children under the age of 18. because what you're going to see is that the Social Security Disability Program is a program that benefits the family. So when you paid into Social Security, not only are you paying into your own benefit, but also any potential benefits, for someone who is under the age of 18, or a spouse that is age 62 and never paid into the program. So that's one of the reporting responsibilities. Any changes in work, family composition, any changes of addresses, phone numbers, we need to know. If the person is not approved, then they will also get a letter that lets them know about their appeals rights. And whether it is Social Security disability or supplemental security income, there are a number of appeals rights that will be explained in that letter. So if the person gets denied at the initial claim, they have the right to appeal that decision. And the first level of appeal, it's called a reconsideration. So once we send the letter, they have 60 days to ask Social Security to reconsider that decision and to look a second time at the person's disability. At the reconsideration level, then it goes to the Disability Determination Services. Someone that didn't make that first decision will look at the reconsideration. We ask if there are new diagnoses, if there are any new medical information to provide that. If the person gets denied at the reconsideration level, then they have the right to ask for an appeal before the administrative law judge, and that judge will determine if that person is disabled. Next. So I touch a little bit on this. So I say that Social Security disability, it's a program that benefits the family. Because let's say, for example, that, if my spouse became disabled and started getting Social Security disabilities and I was age 62, then I could, and I never paid into the Social Security system, I could potentially receive 50% of my spouse's Social Security disability. The same if I had a child of my spouse who's under the age of 16, or a child of any age who has a disability that began prior to age 22. That child could also potentially receive about 50% of whatever the my spouse is entitled to. The same with divorced spouses. So if I was married for 10 years and now I am divorced for at least 2, finally divorced, that spouse could also potentially be eligible. The same with any children under the age of 18, or if 19 and still in high school, they can potentially get 50% of what the disabled individual is entitled to. And also adults, children not married who's had a disability that began prior to age 22, we also take an application to see if we can pay them up to 50% of whatever the disabled worker is receiving. Again, you don't have to worry about this. These are questions that we ask because when we take an application, we want to make sure that we protect anyone and everyone who might be potentially eligible for benefits under that disabled worker Social Security record. Next. All right, so in some instances, and we will ask this, we will not be able to pay any Social Security benefits if, the person has an outstanding warrant for his arrest, confined and convicted of a crime, or has violated a condition of parole or probation. So we will need to know the specifics. It's determined very much by the facts. If they have had such records, and they no longer have it, then we will ask for proof so that we can pay them. But there are instances such as this, that if you one of them applied to the disabled individual, Social Security will not be able to pay benefits. Next. Okay. So Social Security has incentives for disabled individuals that if the person is able to work and they want to work, then they can work, right? So let's do it by example. So if I became disabled last year and I've been receiving benefits since last year, and now I want to go back to work and still keep my Social Security disability benefits, I can. So as long as I'm not engaging, again, in substantial work, 1460 per month in 2023, then I will be able to keep my benefits. Now, there is a rule, and we have a publication called Working While Disabled, How SSA Can Help, which says that, if I've been receiving benefits since last year, disability benefits, and this is my first time that I'm going back to work after being on disability, then we have this work incentives called the 9-month trial work period, that the person just needs to let Social Security know that they have gone back to work. And during those 9 months, the disabled individual can earn as much as they want and still keep their Social Security disability benefits. That's one of the work incentives that Social Security has. Then again, if someone is disabled getting disability benefits, or even, self-employed individuals, they're responsible to contact Social Security, let us know that they started to work, how much are their earnings, how many hours they're working, so that we can keep track of their work. Now, they're also responsible to report their wages. And then another advantage of creating that My Social Security online is that if we find someone disabled, they're getting benefits now, they will be able to report their wages online through the My Social Security account. If they're unable to open the account, they will have to, once a month, they will have to provide copies of those wages. But the most effective way, it's to go ahead, create the account, report your wages online once a month through the My Social Security account. Next. All right, so that's the Social Security Disability Program in a nutshell. I'm going to take some questions because I know that was a lot of information, and just so that you know, before I started taking claims, I was probably in training for about 2 years. So we understand that our programs are very confusing. But then again, what I tell, I work with a lot of organizations, agencies, and what I say, do you have a question? Yes, you can call Social Security, but your first stop should be ssa.gov, because all of our publications based on programs can be found online, as well as our policy. So I'm going to stop here because this is the first program, and then I'm going to take some questions if there's some in the chat. Let's see. And Greg Pratt of Bureau of Homeless Services, if you can go ahead and ask your question.
Okay, thanks so much for all the information you gave. Just a couple questions. So if somebody's age 50 and then they turn age 62, I'm not talking about the spouse, but the person's receiving retirement, do they have to start receiving their regular Social Security? Do they continue receiving their disability until they reach like 66 or 67 or 66 and a half, whatever the...
Right, okay, yeah, great question. So so the scenario that Greg is asking is, let's say you have someone who's receiving disability benefits at age 60, prior to age 62, which is the earliest that you can retire under the Social Security retirement program. Well, they will just continue to receive their Social Security disability. It wouldn't change. So when you start getting disability benefits, even if you're not full retirement age for retirement, it is as if you were getting your Social Security at full retirement age. So in your example, if you have someone who is age 50 and applied and got approved for disability, their Social Security disability is as if they were full retirement age. It's 100%. When you apply for disability, it's 100% that you're getting of your benefits, depending on how much you paid into the system. So when that person comes of age of retirement, the benefit would still be the same. It will be 100%. Nothing will change. And then once they attained their full retirement age, it will not be called disability, it will be called retirement. And even though that person has been receiving disability benefits since age 50, excuse me, once they attained their full retirement age, now because their full retirement age, even though they're disabled, there's no earnings limitations and they can work as much as they want.
Okay, thank you. And then you just kept talking about that magic number, 1,460. So if somebody made $1,400 and they applied, does that mean the most they would get in Social Security check would be $60 per month if they kept working, or would it be high? Can it be higher than that?
No, because the first program that I focus on was the Social Security disability. So remember that I said it is an earned right. In order to be eligible for Social Security disability, you have to have worked and paid into the Social Security system. So let's say, for example, that I've worked enough under the program, and my Social Security disability, once I open that my Social Security account, it's $2,000. Well, I've been getting my $2,000, so I feel great. I want to go back to work, and now I know that during 9 months, the first 9 months, and they don't have to be consecutive, from the day that I first became eligible or entitled to Social Security, for those 9 months, I can make as much as I want. So if I'm earning 5,000, 10,000 during those 9 months trial work period, it's okay. I wouldn't lose my benefits. Now, once I completed those 9 months, right? Now we say, well, you can work, you can still get your $2,000, but here's the limit. You cannot earn more than $1,460 per month, but that figure changes every year because everyone, regardless of whether or not you're getting Social Security benefits, we got 8.7% increase. So if there is a cost of living increase again in January of 2024, then that 1460 might be higher. What I tell everyone is that Social Security fiscal year ends September 30th of each year. And then between October and December, SSA will, let the public know if there is a cost of living increase that will be effective in January of the following year. And to know that, I always say, just go to Google, and for whatever year you're looking for, Google 2024, 2025 Social Security changes so that you can be up to date with that number. We call that SGA, substantial gainful activity. So in 2023, it's 1460, 2024 might be higher because of the cost of living increase. Also, and I did gave a link through the email that I sent about the publications, and one, it's called Working While Disabled, how the SSA can help. And that publication explains, the child work period, the SGA, and even some reinstatement provisions that we can look into it if the person is, doesn't qualify for to reinstate their benefits based on those. So there's a lot of information, and that's why we want people to go online to read about the provisions as an option, but you can always visit or call Social Security field office. I know that was a very long explanation, but I try to be as detailed as I can.
That's good. Thank you very much. I appreciate it.
You're welcome.
And I just want to do a quick time check. We have about 20 minutes left for the presentation. I know there's a lot of content, so if you get to 11 o'clock And we still have content left. Know that we will be sending out all the slides and all the content to everybody.
Mm-hmm. So there's a question on the chat that says, is a 9-month work incentive period only for those that are new to SSDI, or can someone who has been on SSDI for a while take advantage of the incentive? And yes, that could be. So the 9-month trial work period will be, usually provided to those that first become eligible. But there's a provision that says, if you were on Social Security disability, there is a provision. I can't don't have it on my mind right now. But yes, there might be a possibility that even if you've used your 9-month trial work period, depending on how many years you've been, if you file again and you've worked and paid, and that work will make you eligible in the future, yes, there might be a possibility that you can get a 9-month trial work period again. All right, so I know I only have any other questions. You're welcome. All right, so I'm gonna go move quickly. You say I only have until 11. Okay, so SSI, supplemental security income, it's again, SSDI is for people who paid into the Social Security system. SSI, supplemental security income, is for those that might have paid but not enough that they wouldn't be eligible to receive SSDI benefits in the amount of $934. So when we take an application for SSDI, we'll also look to see whether or not they're eligible for SSI. So if we go to the next slide, the definition for disability is the same, but to be eligible for SSI, you must have limited income and resources. So in 2023, if you're working, let's see, we look at your income to see if you're eligible. Then again, don't make that decision based on your income or resources. Let SSI make that decision. So SSI, it's for individuals who have not paid enough into the Social Security system, children whose medical condition keeps them from learning as someone of their age, individuals age 65 or older, individuals totally or partially blind, and then again, have a medical condition that it's so severe that is going to keep them from working more than 12 months or result in death. The next slide. Then again, same disability definition for someone who's on SSI. They can still be working at the initial claim, make 1,460. We'll take the application. One thing that I didn't mention is that, let's say that the individual has a medical condition so severe that they cannot work, but they're working and earning more than 1,460, regardless of that individual's disability. Unfortunately, Social Security will not look at the individual's disability, but will make a medical decision saying that even though you're disabled, you're engaging in substantial work, and regardless, despite of your disability, not disabled under the Social Security guidelines. The next slide says that, we look at your wages, Social Security benefits, and pensions to determine whether that person might be eligible. SSI is only payable in the US, Northern Mariana Islands. If the person is not a USA citizen, but they were lawfully residing in the United States prior to August 22nd of 1996, they might be potentially eligible. Then again, we have to make a disability decision. For anyone, any person who's not a USA citizen and came to the United States after August of 22 of 1996, they either have to have worked and paid into the system 10 years or have a spouse or a parent who has paid 10 years at least into the program. Next. Okay. So at SSA, we differentiate between earned income and unearned income. Earned income, there's a formula that we use to determine whether or not the person is eligible. But unearned income, it's count dollar for dollar. So the most, for example, the most that we can pay on SSI, it's $914 with the exception of $20. So if you're getting SSA benefits, right? In the SSA benefits are more than $934, then the person wouldn't be eligible for SSI, because then again, the most that we can pay on SSI it's $914. Then unemployment benefits, again, the same thing, pensions, interest, whatever unearned income that you have, it's count dollar for dollar. So if your unearned income exceeds that $934, then the person will not be eligible for SSI. Again, let Social Security make that decision, but know that depending on whether the type of income that you have and how much will determine how much of that $914, which is the maximum SSI benefit, SSA can pay. The next slide, we look at resources, right? So we again make a difference between what resources count, what resources we exclude. So anything as bank accounts, CDs, IRAs, 401k, stocks, funds, any asset that it's or resources that are liquid, we do it's included to make that determination. So for an individual applying for SSI, the resource limit it's 2,000. For a couple, it's 3,000. So even if the person is disabled, but has bank accounts that exceed as an individual $2,000, they wouldn't be eligible for benefits. Some of the things that SSA excludes, it's if you have a home and you live in that house, we excluded. If you have your first car, we excluded. Burial plots for you or your family, and up to $1,500 for set aside for burial. And next, living arrangements. So when it comes to SSI, it matters where the person lives, who are they living with, do they buy their food separate, are they renting a room, are they in an institution, where the medical expenses are being paid by Medicare. If so, if more than 50% of the person's medical expenses are being paid by Medicare, instead of that $914, the person would only get $30. But then once that person is discharged from the institution, it might go back to the 914. So depending on who you live with, whether you're responsible to pay rent will determine how much out of that $914 the person will receive. And then again, let SSA make that determination. The next slide, reporting responsibility. SSI, it's very sensitive in that because it is based on need and it comes from federal funds. There are a number of situations, scenarios that the person needs to report. If they start working, if they stop working, they need to report that. And just like Social Security, they can report their wages online by creating a My Social Security account. The next slide provides you a list of what the SSI applicant or SSI recipient must report to Social Security. Changes of addresses, living arrangements, and someone moves into the house, outside the house, if they start working, if they stop working, if they won the lottery, any changes in resources if they get married, if they get divorced. Because you'll see that if you are on SSI and you get married and your spouse has income, then we will count that as spouse's income. Changing the immigration citizenship, every type of benefit at Social Security you have must have some sort of legal status, immigration status. If you're eligible for any other benefits, admission or discharge from an institution, hospital, nursing home, jails, you need to let us know. Changing schools attendance. If you're a child and you're working, and you're a full-time student, there's an income exclusion up to about $8,700. So but you must be in school full-time, and then you'll get your full SSI benefits. If you go outside the United States for a full calendar month or 30 consecutive days or more, you need to let the agency know, because SSI is only payable in the US. And then again, obviously, any unsatisfied felony or warrants for someone's arrest, for escape from custody, flight to avoid prosecution, confinement, or flight escape must be reported, because in those instances, then SSI is not payable. And I'm almost done. Next slide. Okay. I won't get into the SSI for children. I'm not sure many of you help children, but then again, the child for SSI purpose would be a person with a disability who's neither married nor head of household, under the age of 18, or someone who's under the age of 22, and is a full-time student in school. Then again, when it comes to children, we take the parent's income into consideration to determine whether the child might be potentially eligible. So just like with Social Security disability, we first look at Social Security disability, we look at the person's work, right, and see if they're eligible. For SSI, we look at the income and resources, whether you're an individual, but when it comes to children, we look at the parent's income and resources to determine if the child is eligible first based on income and resources. So whether you're an individual or a child, if you're eligible, potentially eligible first based on income and resources, then we forward the application to the Disability Determination Services, and the same process that I explained at the initial claim and the reconsideration and appeals levels, the same applied for children. I want to leave you with, there's a lot of information, a lot of requirements for both of our programs. You can share my PowerPoint so that if you want to go over it and read it, you can have it. And then again, if you guys have any questions, my first stop would be ssa.gov. Like I said, we have many publications that go into the types of benefits, and also any potential benefits for family members, like I explained. Also, if you have a question, I can guide you into finding the resources that you need. So you can go ahead and share my email as well with all participants. If you want a presentation for your organization, I am available, whether virtually or in person. But then again, I just don't want this to be a one-time presentation, but I want to foster a relationship with each one of you, because, we understand it's a lot, but the more you read about it, the easier it will become. I'm not sure which organizations help individuals with submit an application, but I can do another session where I can show you, our website, ssa.gov, teach you how to navigate it and submit an application on someone's behalf, and you can see how easy it could be to submit an application online. Now, another thing that I want you to know is if you visit ssa.gov, and we've made it easier to identify the types of programs. So on the top of the website, if you go to ssa.gov, it will give you the types of benefits that SSA administers. And one of those is SSI. Now, whether you're an individual or helping someone, you can go online at ssa.gov/SSI, and you can set up request an appointment online for SSI. You don't have to call a field office or visit once. So that's just one of the many benefits of going online, and the the types of task-oriented services that the agency has been able to add online at ssa.gov. I only have 3 minutes. I will take any questions.
Thank you so much, Mary Ellen. And I know it is a lot of information, and it's kind of the perfect segue. I have a very brief presentation I just want to touch on today, because we do have another presentation. But given the information we just received, and knowing that's only a partial scope of what Social Security encompasses, this is very complicated, right? The fact that it took 2 years to get trained on it. Imagine being a person experiencing homelessness or at risk of experiencing homelessness, trying to navigate the system. It's overwhelming for us as providers. So one of the resources I wanted to share today is a program called SOAR. Some of you have heard of, because you are super trained. Oh, you can see that? So Social Security Outreach, Access, and Recovery is a partnership between SAMHSA and the Social Security Administration. So what this is a free online course that is self-paced that allows individuals to apply for Social Security, and it actually teaches you all as providers kind of the process of what goes into a Social Security application. It's specifically for individuals who are at risk of or experiencing homelessness and have a serious mental illness and or co-occurring disorder. The great thing about it, though, is not only is it free, it is eligible up to 20 credits or 20 CEUs from the National Association of Social Workers. Like I said, it's self-paced. It provides practice cases that you can complete as you would with an actual individual. And you submit it to a SOAR TA who reviews it and then sends personalized feedback back to you. It takes about 20 hours to complete, but it really is a comprehensive overview about everything that Social Security looks at. We know the challenges with this. We just heard about some of the challenges. We also know that capacity for you all is very limited. So the faster we can streamline some of these things and get applications in and get more information in on that initial application to hopefully get a better outcome. That's someone's rent, right? I mean, this is really a life-changing decision for folks. So I have much more information on it, but I want to get to our next presentation. So I'm just going to touch on a couple of things. One of the biggest takeaways I had when I went through the course was that link to functional impairment for that substantial gainful activity level, right? So I focus so much on proving someone is disabled with Social Security and forgetting that link back, that once I had that link, we really saw an improvement on application approvals from Social Security. So for states that have a well-oiled machine with SOAR, they have very high outcomes. They have an average of 81% on initial applications for the SOAR model. New Hampshire is not one of those states yet. We have a ways to go with it, but we are trying to get it off the ground. 2022, the national average for SOAR was 68% approval on initial application, and that was within 153 days. So again, like life-changing, right? The complications of the system and the impacts to individuals that we serve is huge. So I will send out further information following this meeting, how to access the course, how to register for the course. And again, it's self-paced, so on your own time as you see fit, but it really teaches you a lot about the process and how you as an individual can impact change within this very complicated system. So with that said, I'm going to move on in our agenda. One of the things that we've been focusing on as a balanced state continuum is anti-discrimination and what that looks like. So last time we met, which was 2 months ago, we focused on the equal access rule for HUD. And this month, we wanted to move that next in the series to fair housing. So we're excited to welcome Sarah Burke-Cohen from the New Hampshire Commission for Human Rights. And I'm hoping, Sarah, that you can share your screen.
Well, I'm hoping too. Otherwise, I put this nice presentation together for nothing. I think it's this one. So, please.
Yay!
All right,
All
great.
right.
All right. Hi, everybody. I am Sarah Burke-Cohen. I'm the Assistant Director at the New Hampshire Commission for Human Rights. I do have this fancy presentation. So I'm talking to you about a couple of things today. I'm talking to you about the Fair Housing Act. And I'm also talking to you about public accommodation. And so the reason I'm talking to you about them both is because a lot of you work in sort of areas where these two sort of aspects of the law kind of join together or overlap. So the laws against discrimination. Let's see if it will work. There we go. The laws against discrimination are RSA 354A. You also have federal laws at work. HUD enforces the Fair Housing Act. And there are some public accommodation, some intertwining of public accommodation in HUD laws, but mainly places of public accommodation are enforced on the state level. So we are the enforcement agency, the New Hampshire Commission for Human Rights. We are based out of Concord, but we cover the entire state. I'll tell you a little bit about us. So we have 7 commissioners that are appointed by governor and council. They are our fact finders. They're our judges, so to speak. We have an executive director, myself, 5 investigators, a part-time paralegal, and a part-time secretary. We are the little engine that could. So we do all enforcement for discrimination in every aspect of sort of life, right? We do, we enforce the laws when it comes to employment, housing, public accommodation, and public education K through 12. So we do everything. Now, some of you understand or have heard about protected classes. So the laws against discrimination, the Fair Housing Act, they sort of protect certain classes of people, or you can discriminate based on certain classes of people, I should say. So you have age, sex, sexual orientation, gender identity, marital status, religion, race, color, national origin, physical and mental disability, and familial status is in housing only. I'm going to tell you a couple of things because some of you who may know, may have read the Federal Fair Housing Act will note that sexual orientation and gender identity are not identified specifically in the Federal Fair Housing Act. Instead, case law has interpreted the Federal Fair Housing Act to sort of sex umbrellas, sexual orientation and gender identity and pregnancy all under one sort of little umbrella called sex. So New Hampshire has decided to pull those couple of things out specifically. So it is clear statutorily that these individuals are covered based on their sexual orientation or gender identity. Age can be any age, right? I say 40 plus federally. I'm sorry, that was my employment law sort of bled over into this. Age is anybody, right? You can discriminate on, somebody saying, hey, you can't rent my place because you're only 18 and I only rent to somebody who's 35. That could be considered discriminatory on its face. Marital status is also included in the state law. Not many marital status cases we see, but it really is, hey, I'm divorced, I'm not, I'm married. That's the type of cases we see. And it really, a lot of times it used to revolve around children. I have children and I'm sort of divorced kind of thing. Let me tell you briefly about our process so you can be aware of it. Like I said, we are located here in Concord. We do have folks who come visit us and we have walk-in traffic. Most of our cases are received to us via phone. We sort of are the agency that does everything because we are the enforcement agency. We also help folks file their charge here as a courtesy for people who are unrepresented, which are the majority of people who are filing with us. And so what that means is we don't represent them. We just make sure that they are putting down what they need to in order for our investigators to investigate their case. So they talk to our intake coordinator. She helps them put everything on the right forms because we are a state agency. There are forms involved. So she helps them get it on the appropriate form. The charge gets docketed here. It has to be signed, and it has to be signed before a notary. Now, most of our agency, everybody's a notary, so we have that for free. There's also notaries at banks, city halls, etc. After it's docketed with us, the respondent is notified, and then there's a Y in the road, so to speak, that the case can proceed with us, or the case can proceed to court, if that would mean that the complainant has to remove it to court. We're an administrative agency. A lot of folks who are pro se feel more comfortable with us because we are not a court process. So we are a little bit more informal. We still are formal enough that we investigate, and we're not, we don't have our hair down and kind of just chilling, but we are formal enough that we take in evidence, but not formal like the court process. So we get in, after the charge is docketed and the notice goes out to the respondent, we ask for some information from the respondent to sort of get the information gathered for our investigator. Sometimes that means we do amendments if we didn't name, if a complainant maybe only knows the name of an entity as, I'm going to use Dunkin' Donuts as an entity. I'm not saying that we have charges against them. I'm just using this as an entity, mostly because I got a coffee there this morning, so it's fresh in my mind. Dunkin' Donuts isn't actually Dunkin' Donuts, right? It is an actual franchise. So Dunkin' Donuts is usually, Joe Smith, LLC doing business as Dunkin' Donuts. So maybe a complainant calls and says, hey, it's Dunkin' Donuts. We serve Dunkin' Donuts. Dunkin' Donuts says, that's not us. And we get them named right. Gets assigned to an investigator here. We have, our statute allows us to ask for pretty much anything. We like to do it without having to get the Attorney General's office involved and subpoenas involved, but sometimes we do. But we can ask for anything. So what does that mean? That means we can ask for, if it was a housing case and there were employees that were harassing tenants, we can ask for personnel files of the harasser, right? To see, hey, you're saying that they've never had a problem before. We want to see their performance, evaluation, because maybe we have evidence that there have been previous problems that haven't been addressed. So we have a really huge toolbox, toolkit that we can pull information from. It also means that we can interview folks. It's not a deposition. It's not that formal. It is, a one-on-one interview that we record with everybody's permission, because that is what state law says. So we have all of these. We also have the ability to mediate. We have a free mediation program. So a lot of times we try to get the parties to resolve the case. I mean, a lot of our cases, we're talking about things that have happened that people want resolved quickly. I told you there's only 5 investigators for our entire state. So it's hard for us to get to all of our cases at the same time. So we have about 400 cases here right now pending, and they keep coming in, unfortunately. So we do have this free mediation program. Our mediators are, professional mediators, retired judges, attorneys. They are people that we didn't just pull people off the street and say, hey, let's mediate our cases for us. They are professionals, and they do help our complainants get their cases resolved quickly. If that doesn't happen, it moves on to our investigating. Our commissioner makes a decision. Our commissioner makes a decision of whether there's enough evidence to find probable cause, move it along in our process, or there's just not enough evidence to say that there's a potential violation of the law, and the case gets dismissed. If it moves on in our process, it keeps moving on towards public hearing. there is an opportunity for both parties after probable cause to remove it to court or have a public hearing before us. So let's get to what you all are here for, right? We're talking about the Federal Fair Housing Act and the State Fair Housing Act. So both provide access to housing without discrimination. Who does it cover? It covers pretty much everybody, all housing providers, right? There are some exceptions to the housing discrimination laws, to the Fair Housing Acts. So those are, it's owner occupied buildings, right? Hey, I live here and I can pick who I want to live here as long as I am not sort of in the business of being a landlord. That means I have either 4 units or fewer for federal or 3 units or fewer in the building for state. There's also housing that's operated by organizations or private clubs, that those operations by private clubs or religious entities are very specific, that the people, the members, or the people that you are providing housing for have to be in that club or that religion. That has to be a requirement. Can it be a requirement? It can be. However, if you're renting or allowing other people in, then you are considered public. It is not considered, it is no longer considered a private club or a religious club. There's also housing exceptions for housing for the elderly. That means 55 plus communities. And if people have questions, I can certainly answer that. I'm not going to go into the details of that right now, but I can certainly answer that. It's also single family homes. If I sell a house, if I have buy a house and I sell a house and I don't use any rental, a broker or real estate agent or anything, I can actually do whatever I want with my house. However, if I'm selling more than one of those houses, if I'm somebody who's flipping houses, that means I'm in the business. So I am no longer under that exception. So let's talk a little bit about where things intersect. Okay, so for the Federal Fair Housing Act and for the State Fair Housing Act, we're just going to call them the Fair Housing Acts. It's a little easier for me. Dwelling is defined as follows. It means any building, structure, or portion thereof, which is occupied as or designed or intended for occupancy as a residence by one or more families in any vacant land which is offered for sale or lease for the construction or location thereof of any such building, structure, or portion thereof. So a dwelling is actually someplace where somebody is living, right? It is not somebody, it's not a hotel where somebody's living there kind of hey, I'm going to go stay at a hotel tonight and then be out tomorrow. It really is some intended for occupancy. It means like permanent occupancy. So that's the Fair Housing Act, right? So what we're talking about is for those of you who rent apartments to folks, even if they're transitioning apartments, right? Hey, this person's only going to be here for 3 months. It's a 3-month lease. That's how our transition program works. It's still considered a dwelling because they're permanent there, quote unquote, more permanent there than at a hotel. Now, where some of the other agencies that I noticed on here fall are places of public accommodation. So places of public accommodation do include hotels. They also include homeless shelters. So places of public accommodation are pretty much any place that is open to the public, right? So if I am a hotel and I'm open to everybody because I'm not a private entity, I'm open to everybody, I fall under as a place of public accommodation. You can see it in the definition, right? It says hotel right there. Or lodging for transient guests. I think that is supposed to be the definition of homeless shelters there. That's my interpretation of that, but that's how that falls. So what that means is you have 2 laws, intersecting laws, sort of the Fair Housing Act portion or the housing portion of RSA 354A and the places of public accommodation portion of RSA 354A that mean that entities can't discriminate based on those protected classes, right? So, and when I say based on those protected classes, it's all of the protected classes that are limited. Even if you have a problem with some, one of the protected classes, if you are open to the public, the law says that you cannot discriminate on that protected class. So things that are prohibited under fair housing practices, prohibited practices, right? Differing, disparate, terms or conditions, right? It means that you can't say, let's say for, let's say women are allowed to rent apartments, but men aren't in this building, right? That would be differing treatment for different type, people that are protected. Steering, it means you can't tell families with children that they can only rent on the first floor because that's where families belong. But you don't have any first floor apartments open, but you have an apartment open on the third floor. Doesn't matter. You can't steer them to that building. You can't steer people, hey, this is shiny building A, and we're only allowing, no families are allowed in this building. It's only single folks allowed in this building. But sort of not shiny building B is for families because it's dirty and it's not as kept up. That would be considered steering, and that is a prohibited practice. There's exclusionary zoning, which isn't going to be applicable to most of you. There's refusal to rent, right, for discriminatory reasons. There's also discriminatory advertisements that say no children allowed. That is a discriminatory advertisement and could be a chargeable offense here. Also means failures to provide reasonable accommodations or modifications for a person with a disability. If you have a tenant that needs temporary, has a disability and needs maybe handicap accessible ramp, that means you would need to, as long as there's medical provider documentation to back it up, either allow that to be built by the tenant, or if you receive HUD funding, that you would have to do that modification yourself. There's also retaliation under fair housing and places of public accommodation under the law, under RSA 354A. It means that if somebody alleges that you are discriminating against them and files a charge, or even just says, hey, I think you're discriminating against me, it doesn't mean that you can retaliate against them by sending them an eviction notice if you are landlord tenant, or putting them on a no trespass list because, hey, you filed a charge against us, so you're out of here and we're going to make sure you don't come back. So that would be considered retaliation, and it's against the law. Let's talk a little bit about places of public accommodation and prohibited practice. So refuse, withhold, or deny accommodations, right? You can't, let some people in and some people not in based on their protected class. You can't publish that. Hey, you're not welcome here if you are a man. You're not welcome here if you're a family with children. That would be, a prohibited practice, because if you're open for the public, you're open for all of the public. Again, it comes to failure to provide reasonable accommodations or modifications for places of a public accommodation. A lot of times that is service animals, right? Hey, I have a service animal. I'm not talking about emotional support animals here. I know HUD has some different rules. They have an umbrella for assistance animals, which includes service animals and emotional support animals. That's different, but I'm talking for places of public accommodation, service animals, animals that are trained to do something, not just I like having Fluffy and she's nice and she helps with X. It's I have Fluffy and Fluffy can tell me when I am going into diabetic shock. That would be an animal that you would have to allow in a place of public accommodation and not charge any fees for, certainly unless somehow the animal chews through walls or something. If there's destruction of property, then you can charge reasonable fees because of the destruction of property. Again, there's retaliation under places of public accommodation. I'm gonna watch a quick video. I like videos. I don't know why it's so grainy. I've been having some trouble getting it not grainy. So, but this really kind of throws out what the Fair Housing Act is about. I'm hoping you have sound. Let me know if you don't.
Let's play a game. Let's pretend for a moment. You own an apartment building and I want to rent from you. I have a steady job, make a good salary, and have a good credit history. Would you rent your place to me? How about now? Do you still like me?
Very quiet.
What if I have an accent or a last name that sounds foreign? What if I have a disability? What if I'm a single parent? Would you steer me away? Would you close the door? Would you? The Fair Housing Act protects your right to live where you want, no matter what your race, color, national origin, sex, religion, disability, or family status. If you think you've been discriminated against, call us. Fair housing. It's not an option. It's the law.
Sounds so, at the end. So let me talk to you. I wish you all were in person because it's a little better when we do these in person, but I want you to take a quick gander at this scenario. Especially, and think of it from from both the perspective of places of public accommodation, right? For those of you having folks sort of come in and stay, lodging, right? Of either hotels, transient folks, or from the perspective of, rentals, right? So I'm going to give you a second. I'm going to have some more water and then we can talk about it. So first question is, can the owner deny the application based on the revelation that the person is going to be required to use a wheelchair permanently? Anybody want to jump in and give an answer? Nobody does? All right. So the answer is no, right. Yay. No, they can't. Right. And that would also be for some, for both places of public. You can't deny somebody access. Now, I know with places of public accommodation, for those that I assume most of the folks on here have are sort of up to date on their accessibility. I know there are accessibility laws and rules when it comes to properties that are sort of older and have not been renovated for significant times. I think it's 1988, maybe, when they went through the ADA again. But I know there's rules. So we're going to go with that. Everything's accessible, right? You can't just deny, you can't deny that person, right? Can the owner make specific inquiries about, the disability? Probably not, right? So some of you are going, well, wait a minute though, they're asking for modifications. Like, don't we get something? That you can ask for that sort of brief medical documentation, right? This one is a bit more obvious, right? She or he or she is in a wheelchair. So there's an obvious disability happening here, right? But if she's asking for a ramp, you can certainly ask for what I would coin as a prescription for it, right? A medical provider that says, hey, Sally has a disability and needs a ramp. You can ask for that, but that's it. You can't ask for, well, what's her specific disability? What does it consist of? What is, can I have her medical records? That's not something you can ask for, either under the Fair Housing Act or as a place of public accommodation. You can ask for that basic, hey, I'm not sure, like for, a service animal, if the service animal is trained to do something, then clearly they are welcome at any place, right? You don't need medical documentation, technically, if they're a service animal. If you have an emotional support animal, if you are renting a property, if you are renting an apartment and somebody says they have an emotional support animal, you can ask for a prescription for that emotional support animal in a housing situation, right? Because that's the only place emotional support animals are going to be allowed, is when you're renting a property. So let's talk about if the tenant gets into the unit. If you have a tenant that has a disability or gets one, so to speak, when they are in the unit. So do you have to install the wheelchair ramp and make the modification? So the answer to that generally is probably yes, right? That you need to allow that modification to take place, right? Obviously, it needs to be safe. It needs to be installed properly. Who pays for it? That really is, it depends. It depends on who you get your funding from. from. If you get HUD funding of any sort, generally you're going to have to pay for the modification. If you do not, then that person has to pay for the modification, but you have to allow it. Okay. Let's talk about occupancy standards. Okay. So this has a lot to do with familial status. You have, in this situation, we have family of 5, 2 adults, 3 children, right? Landlord has 2 vacancies, one's on the 1st floor, one's on the third floor. Now, this actually isn't totally out of the norm. It's a 2-bedroom unit. That's what we have a lot of. There aren't a lot of 3 or 4 bedroom units out there. So it's a 2-bedroom unit. Can the landlord offer just the 1st floor unit because the family, because only families live on the 1st floor because it's too loud for them to be on the 3rd floor? What do you think? No, Sarah, I don't think they can do that. Right. They can't. You can't steer them to one apartment over the other. You know, families can live wherever families can live, right? Now, can they talk about the unsuitability of the property because there's a family, there's 3 children and only 2 bedrooms? The short answer to that is probably not. So when HUD looks at properties and the HRC, we look at properties in terms of places where people can't sleep. People can't sleep in the bathroom. Nobody wants to have a bed in a bathtub. HUD and the HRC, we frown on that. People also can't sleep in the kitchen. That is not considered someplace where somebody can sleep. However, there is a living room. A living room could be someplace where somebody could sleep, right? Or a den or a study or whatever you want to call it. What about the 3 kids in a 1 bedroom? Well, what if there's like a girl and a boy in there? There's no law that says that can't happen. A girl and a boy can share a bedroom, children. But HUD looks at it from the perspective of, okay, we're going to look at it from, okay, there's a living room, so somebody can sleep in there, and there's 2 bedrooms, people can sleep in those rooms. Now, where things come into play, especially in New Hampshire in some areas, is septic systems, right? We all aren't on public water here. So there is sometimes where septic systems come into play because, hey, we just don't have the occupancy is limited to what our septic allows, right? So sometimes that does come into play and that will be considered when it comes to fair housing. Hey, well, you know, if we have 5 people in here, our septic system is literally going to explode. So HUD takes that into consideration, as would we. But when it comes to occupancy and the number of people in the property, right, we certainly look at what other areas are available for sleeping in a property. So let's talk about the 3rd scenario. Everybody's favorite, I'm sure, are assistance animals or service animals, right? So tenant has a service animal, right? I'm sorry, this is an emotional support animal, right? So we're talking about a rental, right? Because emotional support animals don't apply to places of public accommodation. And the key words here are the dog would enhance the tenant's ability to use and enjoy the housing, right? So that's the language you look for emotional support animals. They're not actually trained to do something, but they're going to enhance the person's life. It means, hey, a lot of times it applies to people who have mental health disabilities, helps the person get up in the morning to have something to care for, right? Helps people, their blood pressure go down when they're having an anxiety attack, but it's not really trained to do anything but just be there. So for assistance animals, for emotional support animals, can you charge a pet deposit? The answer is no, right? Can you bar a dog? Hey, this is a, let's call the pink elephant out in the service animal or assistance animal room. It's a pit bull. Oh my goodness. I can't have, no, my insurance won't cover it. Well, I'm going to tell you that HUD has guidance on that, and HUD doesn't buy into that insurance right away. HUD says, well, then you need to look for other insurance. And if there's other insurance available for you that will cover German Shepherds, pit bulls, Dobermans, Rottweilers, then you need to seek out and get that insurance. if the other insurance available that covers these breeds is unreasonable in cost, then they will take that into consideration with regard to a denial. But otherwise, you can't just bar an assistance animal based on the breed, because consider this, a lot of service animals, right? This is different, right? This is includes places of public accommodation, are breeds like German Shepherds, which a lot of insurances won't cover. Now, back to the pet deposit for a second. What does that mean on the way out if there's a security deposit involved? Can I sort of backdoor the pet deposit by charging against the security deposit on the way out? The short answer is no. You can't backdoor the pet deposit with using the security deposit. However, that doesn't mean if there is destruction to the property that would fall under the use of the security deposit. If it's by the animal, you can certainly charge against the security deposit for destruction of the property. But you can't use it as a way to charge a pet deposit. That's what I have. I know it was brief and quick and to the point, but I really think that you all probably have questions. So what do you have? What questions would you like do you have for me? And are there some in the thing that I didn't? Landlords don't always have to grant.
Hi, I do have one.
Yep.
Something that you did mention about, can you go into further explanation as if the landlord's receiving HUD, is that, what does that entail? So HUD is paying the rent or some sort of assistance? And
So that would be if you're getting HUD funding so if you're, I think like a low income tax credit, if you're receiving HUD funding, right? If you're receiving, hey, we're receiving funding for, we're a public housing authority, or we are receiving other types of HUD funding. I can't figure one. I think that I think it also applies to, what is that called? CDBG, maybe?
CDBG?
Yeah, I believe it applies to those grants. If you're receiving those funds for something, then it would be included as receiving HUD funding. It does not necessarily mean if somebody has a Section 8 voucher or an HCV voucher, that means you are getting HUD funding. It doesn't necessarily mean that you would have to pay for the modification, because Section 8 HCV is a little bit different, because are you getting HUD funding? There's some question on that, right? Because the person is getting HUD funding to pay for you, or getting voucher funding to pay you the other portion, the subsidy. But are you as the landlord getting the HUD funding? There is question besides that. So that may mean you may not have to pay for a reasonable modification. It may mean that the person would have to pay for that modification instead. With regard to, Carmen actually said something about landlords don't always, are you having trouble hearing me? Can everybody hear me okay? Was it just
Yes.
okay. For landlords, they don't always have to grant a reasonable modification, right? Reasonable accommodations are adjustments to rules and procedures. Reasonable modifications are physical modifications. So if there isn't, right, Carmen brought up, if there isn't room for an appropriate ramp, right, then no, you wouldn't have to install a ramp that's not going to be appropriate. If you have a ramp that's like this, that's not going to help anybody. So yes, there are times when there isn't an ability to grant a reasonable modification because there isn't appropriate space for it, or the property is old enough that it's not going to work, right? You can't modify the property because it's just how it's set up. So yes, that is true. So yes, Carmen, you are correct in that. There are only a few insurance companies that cover multifamily units. It's very interesting that HUD came up with that guidance, knowing that information. But that is nonetheless the guidance they have come up with. So yeah, it is a bit frustrating that they don't figure that out and maybe get some, help getting more multifamily coverage for folks out there. Other questions? So I didn't leave it up there. I should go back. Sorry, I took my screen down pretty quickly and I didn't mean to. So on the screen is our information, right? Where we are, our email address and our phone number. So we are the enforcement agency. I cannot give you legal advice, but I can certainly walk you through what the law says. I can't tell you what to do, but I can tell you, hey, a reasonable modification is this, or a reasonable accommodation is this, right? A lot of times we see reasonable accommodations. I have seen them in the past as being an accommodation. Hey, I get to go along with your previous presentation, I get Social Security disability and I don't get paid until X time in the month. So I need an accommodation. I need a reasonable accommodation that I don't pay my rent on the 1st. I pay it on X day, because that's when I actually get my disability pay in my bank account. That could be considered a reasonable accommodation because it changes the policies of the property to accommodate somebody because of their disability. So the email address and the phone number are there. Please call with questions. If you want us to do presentation for you on fair housing, we're happy to come out, or on public accommodation. For those of you that fall under that places of public accommodation, you need to keep that in mind, that you just, you aren't falling under the Fair Housing Act, but there is another law that you are falling under when it comes to discrimination, and you have to watch out for that and be cognizant of that. There are definitely a number of, sort of issues that are percolating out there for folks who are falling under places of public accommodation. We're happy to talk with you about them.
And I think to pair into that, BJ Parker had noted in the chat that motels often refuse to accept vouchers from municipalities, even if they have the funds to pay them. Yeah,
that, yeah. And unfortunately, that's a weird spot, right? Because it doesn't necessarily fall within our ability, right, or our jurisdiction, because we don't have, we don't have that protected class. There are other states that do protect folks based on the use of that, vouchers and sort of, income such as that. It's interesting to me that hotels don't, that do refuse it. And the reality is they're not refusing it because they know that the city or town's going to pay it. They're refusing it because of the stigma that comes with receiving a voucher from a city or town, that they feel like, oh, well, that person's going to destroy my property. I mean, the same can be said about folks that receive any type of subsidy. I lived at a condo association, and at the time I was working for New Hampshire Legal Assistance in their fair housing program, and I lived there, and the number of people that would come to the board and say, we don't want anybody with a Section 8 voucher renting here because we think they're going to destroy their property. Well, that's not the reality. The reality is you have the same likelihood of somebody who's not receiving a voucher destroying your property as a renter as you do with somebody who is receiving a voucher. And considering that vouchers take, what is the wait now? 8 years still? 7 or 8 years, I think, right? I mean, the reality is most people who finally get a voucher want to keep the voucher. They don't want to lose that voucher because they've waited for 7 or 8 years and struggled for 7 or 8 years to get that voucher. 7 to 11 years. Wow. Wow.
It depends on the type of the voucher.
Yeah, right. Yeah, that seems, and it's just, yeah, we'll just leave it at that. That's crazy. So.
And I just want to remind all of our lovely COC subrecipient agencies that all the participants in your projects can submit reasonable accommodations to your projects, and they have to be kept on file. And secondly, if there is a financial impact to your project because of that reasonable accommodation, it has to be sent to the Bureau of Homeless Services so that we can review it. And And we will review those things for, such as they're looking for like an assigned parking space for a person with mobility impairment, or a lower mailbox for someone who is in a wheelchair. Any of those things. So just make sure you are sending those reasonable accommodations along. And if you have any questions, you can reach out to me, but all that information is in the policy and procedure manual as well.
And I'm going to kind of sort of go on that is you should be keeping documentation. If somebody asks you for an accommodation, let me say, I'm the landlord and Mandy rents for me. And Mandy stops me in the hallway and says, Sarah, I need a reasonable accommodation because I have insert need for accommodation here. And she stops me in the hallway and asks me, you can ask her to put it in writing for you, right? It's a good idea to always have it in writing. I assume most of you keep some sort of tenant file or file on even people who, if you're a homeless shelter, that come in and out because you want to keep their information, you need their information, right? Put it in their file so that it's there, or your reason for maybe if it's a situation where, like Carmen said, that you're going to have to deny the accommodation. Don't just put, hey, Mandy, I'm denying your accommodation. Put why, right? Put, hey, there's no space. I don't know where we could put it. You know, this ramp isn't going to work in this property because X, Y, and Z, right? And we haven't, we haven't made modifications to this property that would make it have to fall into the accessibility laws, right? Or there's other reasons why it can't. Make sure that you put that in writing so people are clear, because if a charge comes to us, then it's in writing, right? And we can say, oh, there was what we call an interactive process, right? There was an interactive process between the tenant and the landlord, or between the place of public accommodation and the client, so that we can see what happened. The same goes for people who allege harassment, right? Hey, you're harassing me based on whatever, right? The Fair Housing Act still covers harassment, right? This isn't sexual harassment isn't just covered by employment, right? It's covered in the Fair Housing arena as well, or harassment based on any of those protected classes, right? You have an obligation to your tenants or clients to do an investigation of that, or figure out what's going on and take action. If you figure out that, yes, there is race, color, national origin, etc., harassment going on of a tenant or client, you need to take action immediately. Now, what does that mean? Does that mean evicting the other person immediately? Maybe not. Maybe it just means you say to the other person, hey, listen, I've done an investigation and I, have found evidence that you are harassing another tenant here. That needs to stop. If it doesn't stop, I'm going to, we're going to move forward with eviction. We're going to move forward with, if somebody at one of the shelters, we're going to move forward with a no trespass order for you, because that harassment is still unacceptable. And it's still something that falls under your jurisdiction, and our jurisdiction, and under the Fair Housing Act. Because remember, when somebody is in housing, they are entitled to quiet enjoyment of that housing, right? And that means, right, free from discrimination, by the landlord and by another party, right? By a third party. Now, does that mean, if somebody down the street, drives by and yells a racial slur towards somebody, that you have to deal with that? No, it's somebody that's in your property. If you have another tenant that's causing problems, then you need to take care of it. If you have a staff member that is causing, is harassing somebody, you need to take care of that. And I'm going to tell you, just like with reasonable accommodations, you need to document what you're doing. Because if you don't document what you're doing, you're like, oh yeah, Mandy came to me and said that, Maria, you're all on the same line. That's why I'm using Maria. Maria was harassing me. She came to me and said Maria was harassing me. And I said, oh, that's too bad. And that's all I do. When the charge of discrimination comes in and I say, well, or the investigator says, what did you do? And I say, oh, I just said that was too bad. Well, that's going to be deficient in that for you, as the respondent, and we're going to have to take action. And, if you get through the process and we find for the complainant, we can fine people or fine entities for their, taking no action. So, you have to keep in mind that the Fair Housing Act covers a lot, as does the place of public accommodation. If you fall under the place of public accommodation and your staff are harassing people or telling people, oh, you can't use this facility, but you can use this facility. Or, when it comes to people for gender identity, if you are purposely not using pronouns that people identify with, that can become harassment pretty quickly. And that can become a charge here. Now, I'm happy, like I said, always happy to answer questions relative to what is covered as a place of public accommodation, what's not, what protected class is covered, what's not. Happy to answer that, but you have to keep in mind that harassment still falls into both of these categories. It is very. And I agree with Carmen about it's hard to control the behavior of other people. I agree with you 100%. It's hard to evict somebody for discriminating against a neighbor. It can happen, but maybe if this is a facility that there are other, we've had facilities move people before. Hey, this tenant is using racially inappropriate, language towards a tenant. And so the victim is asked, hey, we have another place available. Would this be something you're interested in? The victim is always asked first. Is this something you're interested in? I'm sorry. The harasser's always said, hey, we're moving you, right? And if they refuse, you can certainly ask the victim, or you can ask the victim too. Maybe it's closer to a school, or maybe it's closer to their work and they're willing to move. But otherwise, you can also move hey, I'm thinking that you might want to move, and then I don't have to move forward with the eviction process. If you voluntarily do it, I don't have to evict you. But after a certain amount of time, yeah, you can evict somebody for discrimination, right? Other good cause is in the statute, right? And so other good cause can be her discrimination. But as we all know, the eviction process isn't an easy process, right? It does take a period of time. Any other questions or comments? Maybe. Okay.
Thank you so much, Sarah. I know, especially to hear from both the federal and the state laws regarding fair housing is super helpful, and that intersection with public accommodation. And we can share your PowerPoint after the meeting, too?
Yeah. Yeah.
Okay, excellent. With your contact information for any questions.
Yes.
Beautiful.
All right. I can email that to you in a PDF form.
Perfect.
All right.
Thank you so much.
You are very welcome, everybody.
And we actually had more time than we had anticipated. Christy, do you want to talk briefly about performance monitoring, or?
I can. I was going to send in a test for now, but give me a hot second, and I will. I will be sending out Melissa will send out with the balance of state meeting notes, the continuum of care policies and procedures on reasonable accommodations from the manual for all of you to reference. It is in section 12. And then just briefly, hang on.
And just as a reminder, the balance of state agenda, we did have regional updates, but we anticipated not having enough time for them. So Melissa asked for any regional updates to be sent, and those would be sent out with the minutes.
Give me 1 second, Mandy. So the balance of state annually is required to monitor all continuum of care projects based on performance measures. Those performance measures are included in the reallocation policy that was approved by the balance of state last July. Those performance measures include HUD system performance measures, grant spend down financials, and HMIS data quality and data timeliness. All of those reports were sent out, I believe, at the beginning of April. They usually get sent out between March and April. So any project that's scored below the median score, which was also voted on by the balance of state a couple of years ago, received a performance monitoring report, which requires a corrective action plan be sent to the balance of state, which the executive committee reviews to ensure that each project is actively reviewing their performance each year and making progress towards improving their performance. This is kind of a multi-layered approach because HUD expects each year that the balance of state and continuum of care review each project for performance. We are looking at low performing projects and working with them to provide technical assistance and support to improve those projects. And if those projects don't improve, then looking at either voluntary or involuntary allocation so that we do have high performing projects within our continuum of care. This information also is imperative to our system performance measures. Specifically, measure number 4 is specifically for continuum of care projects that looks at how projects are increasing earned income for the participants in their projects, how they're increasing non-earned income, and how they're increasing connections to mainstream benefits such as WIC and SNAP, transportation, many other things. I have a very detailed explanation and can walk through with any project that has questions about their performance monitoring, how this all ties together, because the balance of state looks at your project each year. For performance monitoring, those scores are also reported to HUD every single year. And then we're also looking at that for scoring purposes for NOFO, both as a balance of state and HUD looks at our scores as well. So it's a very, like a 4-layered process that impacts how we score on our NOFO and what funding we can and cannot receive. So we really try to make sure that we're looking at all levels, the project level, the system level, how it's impacting our balance of state and our NOFO scores each year, and trying to work with projects to increase those numbers. So I think that's all I have. Oh, and in regards to coordinating entry committee, we have a meeting tomorrow, so.
And it's perfect timing because the weed whacking just started right outside my office, so perfect time to end the meeting so I can still hear you all. So again, we will send out all materials that were reviewed today. It's a comprehensive day of content. Send out the presentations, any of the links that were sent by the presenters, as well as some of the regional updates that we received from you all. So thank you all for your time today. We will see you at the next balance of state meeting in a couple of months.